What are key components of an IP licensing agreement? Imagine turning your creative work into a steady income stream. That's what an intellectual property licensing agreement helps you do. It's a legal document that sets the rules for sharing your intellectual property with others. Knowing what makes up this agreement can save you from future headaches. Let's walk through the main parts you need to understand. First, you have to clearly identify the intellectual property involved. This means describing exactly what is being licensed. Whether it's a patent, a trademark, a copyright, or a trade secret, the agreement must specify the type and scope. For example, if it's a patent, include the patent number and what inventions it covers. This clarity helps avoid confusion later. Next is the grant of license. This part explains what rights the licensee gets. It states whether the license is exclusive, meaning only they can use the IP, or non-exclusive, allowing the licensor to license others too. It also covers where the license applies geographically, like in certain countries or regions. The duration or time frame of the license is included, such as a 5-year period, and whether it can be renewed. The scope of use is also detailed, like if the licensee can only use the IP for specific products or services. Financial terms are another key component. This section spells out how the licensee will pay for the rights. It might include an upfront fee, ongoing royalties based on sales, or milestone payments. Payment schedules and methods are clarified, along with rights for the licensor to audit the licensee's records to verify payments. Clear financial terms ensure both sides know what to expect. Ownership and improvements are also important. The agreement confirms that the licensor retains ownership of the IP at all times. It addresses whether the licensee can make modifications or improvements. If they do, the agreement might requiring the licensee to license those improvements back to the owner, called grant-back provisions. Quality control and use restrictions help protect the value of the IP. For trademarks, the licensor can set standards for quality to maintain brand reputation. The agreement can also limit how the licensee uses the IP, preventing misuse or unauthorized activities. Reporting and record-keeping are necessary for transparency. The licensee might need to provide regular reports on sales or usage. This helps calculate royalties and ensures compliance with the agreement. Warranties and representations are promises made by both parties. The licensor guarantees they own the IP and it doesn't infringe on others' rights. The licensee promises they will use the IP legally. These reduce legal risks and clarify responsibilities. Indemnification and liability clauses allocate responsibility for legal claims. If someone sues over infringement or product issues, these clauses specify who is responsible and who will cover damages. Handling infringement is also covered. The agreement states who will monitor and enforce the IP rights against unauthorized use by third parties. It includes procedures for legal action if needed. Termination and renewal clauses explain how either party can end the agreement. They specify reasons like breach of contract or non-payment. Renewal provisions outline how the agreement can be extended if both sides agree. Finally, confidentiality clauses protect sensitive information shared during the licensing process. These clauses keep proprietary data private and prevent leaks. Putting all these components together creates a clear, balanced licensing agreement. It defines rights, responsibilities, and risks for both the licensor and licensee. Well-drafted agreements help avoid disputes, protect valuable assets, and set the stage for successful commercial use of intellectual property.